DT Production.
Yeah. Greetings. I'm back. It's the Sagent, turning on my L, also known as the Sagent. You know, the Sagent is a compound word. The sage has been historically classified as the ones who know. And an agent is someone who conducts or transacts business on behalf of another. And I'm here transacting and conducting business on behalf of the highest order, the divine. Namaste, the God in me recognizes the God in you. So yeah, we're back again. It's been an exciting start of the week, you know, for us, you know, me, my subscribers, my family, my followers. It's been an exciting week for us because not a lot of times do you see somebody actually go and demonstrate what they're teaching. You know, back in 2012 when I was 21 years old, I went to school to get a certificate for automotive technology. I love cars. I grew up loving vehicles. You see what I'm saying? I built, model cars growing up, things of that nature, and that's what I thought I wanted to do at the time. And when I went, we spent a greater part of class in class. I'm like, how we spending this much time in class and I want to work on a vehicle? I need to put a wrench in my hand and go out there and twist on something. Yeah, so that's what's going on. Alright, so it's not a lot of times that you see somebody go and demonstrate. And you know, it was a blessing that I thought to do what I did because as you can see, that it wasn't a court of record. So I had to have my own record. And none of this is meant to be or construed to be legal advice. It's for informational, educational, and entertainment purposes only. If you need legal advice, please seek yourself a counsel and be advised. But with that being said, it wasn't a court of record, and that's what leads me to, or leads us to this subject of discussion today. Court of record. You see what I'm saying? So, the thing about it is I didn't plan on. I only do that to set up my combination. So me asking that simple question is like a jab to set up my combo. You draw what I'm saying? And okay, it just so happened to be that there wasn't a court reporter. I usually don't see that. I don't think I've ever seen that before, or if I didn't know any better, I didn't pay attention to it. So I'm kind of looking around. I'm like, hold on. In my head, I'm saying it's my head. There's not a court reporter. And I know for this to be a court of record, somebody has to be reporting it or recording it. Huh? So with that being said, please comprehend that you have the right to bring your own stenographer as well. You can bring your own court reporter. You can bring your own court reporter. You see what I'm saying? So that's the fact of the matter. You can bring your own court reporter. Now, with that being said, a court of record, consists of multiple things. But we're not going to go into deep detail about that. But what we're going into detail is you making sure everything is established for and on the record. So if you ever walk into a court proceeding and you don't see a stenographer, a glaring red flag should be going off in your head. A glaring red flag should be going off in your head. Period. A glaring red flag should be going off in your head. If there's no court reporter, where's the evidence of this proceeding? If you got done wrong or someone torted you, how would you prove that? How could you prove that somebody in that proceeding torted you? You couldn't go to you can't go to the clerk's office and go get a record of your proceeding because there isn't one. So that's a kangaroo court. That's a kangaroo court. So let's just see. Let's just see what the definition of it is, because I looked it up in Black's Law Dictionary, the 4th edition, and I didn't see it in there. Okay, a kangaroo court is a mock court, especially one hastily improvised or irregularly conducted. A court characterized by dishonesty or incompetence. A judicial or quasi, y'all remember that word I said for a modern day term, quasi means finesse. A judicial or quasi judicial proceeding, or a group which conducts such proceedings which is without proper authority, abusive, or otherwise unjust. I've seen a lot of quasi courts in federal prison. I've seen a lot of dishonesty and incompetence in federal prison. I've seen a lot of people get held to be sentenced to the authority of other inmates. Okay? Now, you must know the gang members, or the members, what y'all want to call it, the Black Stones, the GD's Vice Lords, the Spanish Disciples. They all have a body of law, and they administer it very well amongst their men, in most times. And it actually keeps down a lot of confusion because they have a body of laws. So if they administer it within their law, they're within proper authority of that, because whoever subjected themselves to the rules of that body of men, if you subject yourself, then you're bound to it. All right? So if we don't have a record, how can we prove anything? That's why we always send our mail certified with the return receipt. That's why you send your mail certified, because you want to have a witness. You just send a mail to these people. Oh, we didn't get that. Well, I sent it on such and such, such and such, such and such. Hey, we ain't got it here. And so where's your evidence? Oh, well, according to this return mail receipt, okay, and the certified mail number, it got delivered on this day, and it was received by Mr. John Doe of your office. So if anything is addressed to you, an employee of yours gets it, then that means you got served, sir. You've been served. The record is so important. If you contracting with somebody, that's why implied contracts, or you know what I'm saying, contracts that were not expressed on paper, are so hard to enforce, because it's your word against his word. No, Judge Judy, I gave dude $500 and he was supposed to give me back $700 and interest, and he didn't pay me. No, Your Honor, he gave me $300 and I said I was going to pay him back $100. Did that happen? No. That didn't happen. And I smoke organic. You know what I'm saying? This just medicine for me. You see, I only hit it a couple of times. It carries me. Give me a little bit of clarity, a mental clarity and peace. So, okay. The record. Record everything. When the bill collectors call you, hey, Mrs. Jane Doe, such and such, this is such and such for ABC LLC, and we're on a recorded line. Can I have the last four of your social security number? And you give it to them. Da, 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 da. Okay, we see right here on this account that you owe such and such, and you didn't pay. They recording you. They have a record. So why don't you? And that's what the weight of the evidence means. Who has a greater preponderance of evidence? Yeah, I really can't disprove that man's claim. You see what I'm saying? So, Black's Law Dictionary, 4th edition, page 425 says, courts of record and courts not of record. The former being, okay, so you got, and get used to law terms. They use the term former and latter. Former means the one in front, and the latter means the backside. So if they give you two choices, the former is the first choice that they gave you. The latter is the second choice. Former, front, latter, back. The former, which is courts of record, being those who act and judicial proceedings are enrolled. That means people are coming in and they're letting know their credentials be known for the record. Now, if you go back and watch my videos when I went to court, did anybody make it known who they were? Now, I just asked, was I entering into any contracts if I passed the bar? My paperwork preceded me. So therefore, I've already had established a stake in the ground before I get there. That's my turret gun. Don't cross that line. I filed a special restricted appearance for it on the record. When I'm here, just in case it might slip my mind one day, I ain't never waived my rights because it's on the record, on paper, under my hand and seal. So I didn't want to go aggravate the situation. Speak in an intelligent tone and get a favorable reply. You don't have to aggravate the situation. I'm such and such doing such and such, such and such. Now, you don't let them start adjudicating until you establish yourself for the record. If you go back to the video, status, jurisdiction, adjudication, I say that. But now, as I've been going along in these courts over these last 6 years, I've been realizing you saved that jurisdiction for the ace in the hole. You playing them spades, you got that ace. Yeah, I'm picking up everything. All right? You keep that ace in the hole. You keep the jurisdiction. So you let your status be known. And then sometimes let them slick on into adjudication, because challenging the jurisdiction of the court is somewhat an extreme matter. You just threw a monkey wrench in everything if you're going to challenge the jurisdiction, and you better know what you're doing. I learned is you got to be tactical, because they're tactical. If they got you here, that's their tactic. Fear, ignorance. And you go in there and you get upset because you know they swindling you, but you don't know how to explain. You don't even know how to protect yourself from getting attacked. And then guess what you do? Due to your ignorance, you become angry. See, anger is a secondary emotion. It's never primary. Something else triggers the anger. Embarrassment. Being scared. Somebody jump out and scare you. Ooh, you be like, mother. They make you mad. Right? So, anger is an open display of ignorance. Educate yourself. Educate. The base word to educate is educe. Means to bring out from within. My education came from my experience. My schooling came from the books. Okay? So courts of record, the former, the courts of record, those who act, and judicial, we saying judicial proceedings are enrolled. So the judicial is Article 3. You have the first three articles. The first is legislative, second, executive, 3, judicial. The legislative and the judicial branches are not one and the same. They are two different branches. That's why they have the separation, the separation doctrine. The separation of powers. They cannot exercise powers that belong to the other ones. So the judicial cannot exercise powers of the legislature. The executive cannot exercise powers of the judicial. It would be tyranny if they could. Okay? So these are judicial proceedings that are enrolled. These people have been made known who they are for the record. It says, or recorded, court of record, for a perpetual memory and testimony, and which have power to fine or imprison for contempt. That's a judicial court. Okay? Error lies to their judgments, and they generally possess a seal. That means the seal of your state. You're going to see that when you walk into the court around here. That's the seal. The big pretty thing that sits behind the judge's head. Go look at the video. The big pretty thing that sits behind the judge's head. It looks like a big old gold coin with a blue rim around it. The seal of your state is going to be in that court. Okay? And courts not of record are those of inferior dignity. Inferior dignity. Which have no power to fine or imprison, and in which the proceedings are not enrolled or recorded. Courts not of records are those of inferior dignity, which have no power to fine or imprison, and which the proceedings are not enrolled or recorded. Please go watch my last video when I go into courts. Did anybody enroll themselves? Did anybody made it known for the record who they were? I'm Judge such and such, and this is who I am. I'm State's Attorney such and such, and this is who I am. And I'm the living man, here making a special restricted appearance on behalf of the defendant as a third-party intervener to settle all charges outstanding. And that's in the Blackstone commentaries, sweetheart. So we see that there's courts of record and courts not of record. So when we walked in, nobody enrolled themselves. There wasn't a stenographer. The dignity of this court is kind of looking, sketchy. Inferior dignity. It looked like a bunch of dressed up people in here, actors. Are you trying to swindle me? Am I not supposed to? It's looking real colorable in here. It's looking real colorable in here. So we paying attention to the several things, because if I didn't catch that, they would have proceeded. It was already people being pushed through. I mean, for me to be able to bound myself to the obligation of a contract, we need to have a record somewhere just in case I need to come back and challenge this thing. Huh? A protection. Before police put on his shirt, he put on that vest. He gonna protect his chest. Your protection. Before a diesel man, before an 18-wheeler hit the road, they gonna make sure everything hooked up, make sure all the lights working and everything for their protection. To those people who are not ready for children, they use protection. So when I step in front of the court, I have my protection. Now, they laid it out for you. That's what's called unambiguous. You can't construe it for nothing else. It's prima facie at first glance on its face. They just laid it out for you in Black's Law Dictionary, 4th edition, page 426. What a court of record or a court not of record means. So let's skip down here to de facto court. De facto means, you know what, I'm going to save it for you. One, de facto court, one established, organized, and exercising its judicial functions under authority of a statute apparently valid, apparently looks valid, though such statute may be in fact unconstitutional and may be afterwards so adjudged, or a court established and acting under the authority of a de facto government. This word de facto keeps popping up. Let's go find it. Black's Law Dictionary, 4th edition, page 504. De facto. In fact, actually, indeed, in reality. So, thus, an office, position, or status existing under a claim or color of right, such as a deputy county clerk. De facto. So let's go back to de facto court, and it says, or a court established and acting under the authority of a de facto government. What does Black's Law Dictionary, page 504, have to say about de facto government? One that maintains itself by a display of force against the will of the rightful legal government and is successful, at least temporarily, in overturning the institutions of the rightful legal government by setting up its own in lieu, which means in place thereof. That was a big pill to swallow. I need a little bit of water. I ain't even gonna lie to you. Matter of fact, we're gonna bounce back. One that de facto government, one that maintains itself by display of force against the will of the rightful legal government. Who is the rightful legal government? You, we the rightful government, the sovereign people, God's creations, the sentient human beings, not no fictitious entity, no corporation. Huh? Not no all caps crap. We the rightful government. The people is the government. So, okay. A de facto court is one established and acting under the authority of a de facto government. So you gotta know who this is trying to attain parity with you and who they are. So let's just see what let's just see what let's see what Penhallow versus Doan's administrators has to say about this. And this is a United States Supreme Court case. Okay? And let's see what's going on. In 1795, the Supreme Court tells us, in as much as every government is an artificial person, an abstraction, and a creature of the mind only, a government can interface only with other artificial persons. The imaginary, having neither actuality nor substance with the nor substance, is foreclosed from creating and attaining parity with the tangible. Who's the tangible? Sounds like human beings to me. It sounds like they're making a distinction between fictitious entities, governments, and corporations trying to attain parity with a living human being. So how are they trying to attain parity with us? Let's see if we can figure out and read between the lines. The legal manifestation of this is that no government, as well as any law, agency, aspect, court, etc., can concern itself with anything other than corporate artificial persons and the contracts between them. Why would the Supreme Court tell us that? Is it because before the actual de jure, which is the opposite of de facto, the de jure government was overturned, that they wanted the people to know their rights? They don't want you to open your eye. They don't want you to open that. What would it benefit us? So, if these artificial persons can't attain parity with us, well, how do they get us to go pay fines and sit in jail? If you play Monopoly, you land on the wrong property, you have to go to jail. But what did you take to jail? Your peace. You put your peace in jail. You didn't go sit in jail for your iron or your little bag of money, whatever those pieces were. You didn't go downsize and go walk on the board and go sit in jail for the piece. The piece went sit in jail because you needed a fiction to play the game Monopoly. Are you John Doe? No, I'm an aggrieved man. Here's a third party intervener. Don't play the name game. I am that I am. Don't go in there trying to, dance around and show off. You will fall into a hole. De facto and de jure. So we can call de facto in modern day terms cap. Y'all ass capping. Y'all are de facto government. Y'all ass capping. I'm with the real ones over here, the nationals. The people who know who they are. And ain't none of y'all. Ain't scared of y'all. And no matter what y'all do or however it turn out, we still gonna take it there with you. The real people. Now, so let's see what we can do about this. Okay? Let's see how we can get this to work out in our benefit. Okay? I thought I marked it off, but I didn't, so I found it kind of fairly quickly. We'd be all right. Okay? So, what you didn't see on that camera, on that video, is what preceded me before I came into that public play with those actors, which is a private administrative process. And the lady, when she made the offer, it was sitting right in front of us. So they're asking you questions to get you to play their game. Listen very closely. The judge asks the agent, why don't you just get your license? Oh, you want to play Mr. Nice Guy? Yeah, I'm going to get my license and do. Come on, man. Come on, man. This your enemy now. He's sly. He's cunning. He's clever. He the same one you read about in the Bible. The serpent. The same one you hear about in the Quran. Shaitan. A'udhu billahi minash shaitan rajim. Bismillahir rahmanir rahim. That deceptive wisdom is attempting to demonstrate on your intelligence in your face, in public. Do you have safeguards here? Because you got your safeguards at home. You got your safeguard in your car, don't you? You got that big shotgun sitting by your door, by your nightstand, don't you? You got your safeguards at home. And in your car, you got your safeguards here? That same deceptive intelligence that deceived people through time is standing in front of you. He's wise. But he's a coward. But he's a strong, formidable opponent. He's not strong because he's inherently strong. He's strong because he understands how to play on one's weakness. And what's your weakness when you walk into this public play? What they'll tell you if you went and jumped in somebody's window and took something out their house and ran with it, and you get arrested and you didn't know that there was a crime. Well, sir, I didn't know that was a crime. Ignorance of the law is no excuse. Sentences, dumbass. Get him out of here. See you, Vic. So, ignorance of the law is no excuse. And that mostly who's held to the strict standard of that is who? The officers, the ones who don't know the Constitution. They only know public policy. Oh, this statute said this, that, and the other. But what the Fourth Amendment say? I remember one day I pulled up on the side of a barbecue place on the rough side of town. You know, the high drug activity areas. And they got the street gang unit. We call them the jump outs. Oh, they intimidating. They don't drive the marked car. They pull up, hop out. And y'all be shook. Hey, bro, who the fuck is y'all playing, man? Oh, we the street gang. Y'all need to start identifying yourselves or something, man. This ain't no plaything. Y'all hopping up trying to scare folks, man. We ain't steadying y'all. So I'm getting out the vehicle. And I'm walking in there because I'm going to get me something to eat. And this street gang punk pull up on me and says, "What's your name?" I said, "Fourth Amendment." Deuces. And then I pimped off on him. Hey, man, hey, you know who you did? You don't know who you dealing with. You think everybody's supposed to go for that, huh? So my paperwork preceded me. After I seen it right there, that's the issue. Don't answer any questions because we're as the king when we're going. So we, as king, we're asking the questions. We're asking the questions. He asked me a question. Why don't you just get your license? I have a question. Is this a court of record? Let's cut to the chase. Let's get to the real business. Let's not play any games because we're in a court. A court is a place where somebody is trying to put liability on first person. Basketball courts. Hoop after hoop after hoop after hoop. Whoever get the most win. Tennis. Ha. 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 They sending them back and forth. Why didn't you get your license? Ha. He sent it to me. Hold on. Is this a court of record? Ha. No. Next question. Ha. Well, we can't proceed. Then I spiked that bitch. Bah. All right, have a nice day. But ordinarily, in the ordinary course of things, it doesn't go like that. I've been in front of that judge before, 7 months ago. And it was a discrepancy with the paperwork. He said, "Would you like to come back to court?" I said, I might. But I had my paperwork out there working on the state's attorney, getting him a default. The court date came. I didn't go. The record never updated. So they playing it slick now because these are not courts of record. They kind of tricked me. I don't like being tricked. Next thing I know, there's a warrant. Another offer to contract. Driving with no license. Traffic warrant for a speeding ticket. Okay. We're going to get this dealt with. It's all right. Because you know if you take this route, you're going to have to go sit in the can a few times. If you don't have to, don't eat the food. It's an uphill battle. You're going to have to fight. Or you going to get involved. Or I'm going to knock your ass out too. So, you're going to get involved. Ain't no say I'm a national and I'm standing on this and you scared to go sit in jail. Oh, you might as well scram, buddy. It ain't sweet. Not at all. Is you standing on this if you got to sit in jail for a year? 2, 3, 4. Didn't they lock Daniel up and throw him in the lion's den, bro? They was salt dude and bow down to the king. The king was salt, man. Hey. Dude, ain't my mama. Get him on out of here. I'm gonna send him to dude in the lion's den. Alright? even to death, condemned to death. My man's Daniel stood on that. He stood on that. He had a chance to sit there and bow down to dude before he went to that den. Like, most of y'all would have copped deuces, bro. No, look, man, I ain't even really on that, bro. Come on, man. I ain't going to that lion's den. I'll just bow down right now. That's what they want you to do. Submit. Well, as a man, I know when to hold and know when to fold. If it's not in your favor, don't fall because of your pride. But we don't submit. No surrender, no retreat. Park the whip high on our feet. So we can't. So what happens is the private administrative process, you accept his offer conditionally. Hey man, I see you want to charge me with a few things. Okay. You want me to pay a fine and 1 year course supervision? I'll take that. Based on your proof of claim though. You know? Prove to me that I don't have the right to travel on the land. And if you go to the right to travel video, we break that down. No need to go into it here. So now, okay, we need to know principles of law in effect when we see them. So if I have this man in default before we make it to court, we have an agreement, we have a contract. What does that act as for you if they proceed to make another offer? Because if you accept the offer, you void your contract. You already got them in default. So I'm telling you that for educational purposes, if you got them in default before you go to court, why would you accept another offer at that court date? You already got him with your contract because he remained silent. Remember tacit admission? He didn't answer your paperwork. He didn't respond to it. He who leaves the battlefield first loses by default. An unrebutted affidavit stands as truth in commerce. Is this not commerce? Does not the Code of Federal Regulations, Chapter 27, Section 72.11 say all crimes, state and federal, are commercial? Keeping house of ill fame, white slaving, illegal gambling, murder, extortion, bribery. Did it not say all crimes, state or federal, are commercial? You want a traffic case? Is this not commercial? Are they not soliciting funds from you? Is this not a lawsuit? Is this not a civil suit? So our contract in his tacit admission to the facts set therein, are they not binding? Is this not a binding contract? Do you not believe in your process? Did you do the paperwork and then get in there and be scared and then say nothing about it? Because they not going to address it. And that's on all five. They is not going to address it. They see it. They see it. My private administrative process set before my eyes on the bench that the lady reached down to grab her papers. I'm looking at them. Did she say anything about it? I was going to get to it, but the man found his out because only one or two things are going to happen. Either he's going to embarrass you or you're going to embarrass him. Either you're not going to let him embarrass you and he's not going to let you embarrass him. The people who he has authority over are in here watching him, along with the other sleep sheep who sit in the pews of this Catholic Church. He not gonna let you embarrass him. I'm gonna get on up out of here if I let you do that, my guy. Excuse me. All right, have a nice day. All right, have a nice day. I'm the highest authority in the room because in their little play, he's the highest authority to them, the person who renders the decision. If he leaves, well, who's holding the torch? You, my brother man. You, my woman, my woman. You holding the torch. You the highest authority in the room, clerk, sovereign. I said this case is dismissed. This case is dismissed. This case is dismissed. 3 times a charm with witnesses. So those people who participated in that play, they're witnesses. They are the record. I still know how to create a record. So if y'all want to come back and play on the back end, I just call one of y'all to the stand. Sir, were you not in this courtroom on this day? Did I not approach you? Did you not see me? So I know I'm hitting several points, and please don't let me lose you. But we are speaking of what this contract that you have with this prosecutor acts as for you in court. And I haven't said the word yet, so I'm going to say it now. It acts as an estoppel. That's spelled E-S-T as in Tom, O-P-P-E-L, estoppel. What's a word that's popping out to you right there in estoppel? Stop. An estoppel is an estoppel arises when one is concluded and forbidden by law to speak against his own act or deed. An estoppel arises when one is concluded and forbidden by law to speak against his own act or deed. So this contract that I have with this man, by way of his silence, acts as an estoppel for any offer that you may be prepared to make here today. Oh, well, the states, you see her made the offer. I didn't even get to the part because the red flag to me was there was no stenographer. I didn't even get to where I wanted to get as far as dealing with this man because I was going to tear him to shreds. Well, we have an agreement here. So the lady who spoke, she actually called me out in the hallway 5 minutes before that. I didn't post that. I said, "Are you going to be the prosecutor bringing the issue today before the court?" I'm one of the. So, is not your head prosecutor such and such? Yes. So you're acting in the lights of your head prosecutor. Well, I'm just an assistant. So you're avoiding my question, ma'am. But nevertheless, go ahead, say what you have to say. Okay. And she attempted to make me an offer in the hallway. I said, well, no. I pulled it out the photo. I said, me and the head attorney, state's attorney, we have an agreement right here. I let her know about our agreement that we have. She said, oh, well, let's go in front of the judge. She didn't want to take it. She knew not to take it because guess what? She knew that was her liability at that point. And lo and behold, I'm the first name called before everybody. I'm the first name called. The man seen my face. He didn't look too pleased to see me because he seen me before and he made a smart little comment and he mocked me. But I'm so pleasant. They told me that he didn't know me at that time. I never been in front of him before the last time I seen him. And I said, I don't sign papers. When they asked me, did I want to sign anything? I said, I don't sign papers. And he winked over at the clerk and said, he's a sovereign. He doesn't sign papers. I said, I'm that by existence. We don't have to say the word. He looked at me. I looked at him. You know who you're dealing with. All right? So he knew after that court date, he told me to send him the paperwork. After he seen it, he must have been in chambers looking at it like, he know what's going on. I can't go out here and play with dude. Because if he know this much, he must know how to get on my ass. So I'm going to look for my first out the next time I see this guy. And that was my second time seeing him again yesterday. And he found his out. I mean, poor guy. It must look terrible to be a judge and walk out of the court where you have authority in submission to a man on the land. A melanated man on the land. The original man on the land. I got this estoppel. This my axe. This my Thor. This my hammer. This his kryptonite. You can't move past this, and this what I'm standing on. Why don't you go get your license? I got a question. We not talking about none of that. This the business. And that's what I'm standing on. So, what other type of estoppels do we have? Estoppel is just the principle of barring someone. Under law of estoppel, where, excuse me. Let's see. Okay, so misleading one party to another. So, okay, estoppel is a barring or impediment which precludes allegation or denial of a certain fact or state of facts in consequence of previous allegation or denial of conduct or admission or in consequence of a final adjudication of the matter in a court of law. So as an American national, what's our court of law? Our court of law is the due process by way of our paperwork. You see what I'm saying? Our court of law is our due process through our paperwork. We're nationals. We go to court through the paperwork, through the record. So when we get and we come to these public places because we wish to remain in honor, but our appearance was made before we got there. Our appearance was made before we got there. Well, how did you appear before you appeared? I filed my appearance into the record. I'm making a special restricted appearance. I'm protecting myself before I make it to your kangaroo court, your court not of record. What y'all got going on here ain't no different than 3-4 people politicking in the backyard about how they finna overthrow their next door neighbor. There's no evidence of the conversation. If I don't have any evidence, why would I conduct any business with you? Why would I agree to owe you anything and we didn't put this on paper? So what type of estoppels do we have? A common law estoppel? Estoppel in common law includes estoppel by record. Estoppel by deed and certain cases of estoppel in pass, which are recognized in courts of law. Estoppel by record. I wonder what that record is. Because they didn't have a reporter. So what record could I estop this man from violating my rights? Well, that record is your private administrative process that you sent to him. A private communication with the return mail receipt mailed through your notary. Drafted by you, mailed through your notary. That's your record. The administrative process is in accordance with Uniform Commercial Code 3-505, the evidence of dishonor. So it doesn't stop anything per se. They can keep going. But guess what? You have evidence of dishonor. So even if you have to initiate an action in a separate and independent court from away from the one that you're being perpetrated upon, you have something to prove what you're alleging. It's an evidence gathering tool. It's an evidence. So let's back up. Estoppel. We're gonna come backwards to the word estop. To stop, bar, or impede, to prevent, to preclude. I'm going to stop him. I'm finna stop him. Back up. I tried to settle this. You ain't want to settle it. There couldn't be a controversy. None exists. And I'm not finna let you step on me. Now go and crawl back in your den, my boy. Because I'm finna swing this sword like Conan. You have estoppel by fraud. Estoppel is a penalty paid by a perpetrator of wrong by affirmative act, which, though without fraudulent intent, may result in legal fraud on another. Well, we know they have a fraudulent intent. But I can explain that. May result in a legal fraud on another. So here's a good example of an affirmative act, though without fraudulent intent, may result in a legal fraud on another. Prison. The prison guards. Okay? He's perpetrating a fraud on you by working the prison, which is a debtor prison that locked up people unjustly through stress, threat, duress, and coercion, and being finessed in these courts. But he doesn't have a fraudulent intent. He's here to work to take care of his family and feed his family. You know, some of the men who worked the halls of the prison were distinguished men, but most of them weren't. Okay? He's not even knowing that he's a part of the fraud. But him working there may result in a legal fraud on another. Harry versus Prince. Harris versus Prince. These are different type of estoppels. Estoppel and pleading. Estoppel and stare decisis. Estoppel. Okay? So we want to be able to stop them from violating our rights. So if you have the right to travel, we understand that they're violating our rights because the stopping of an automobile by a highway patrol officer for inspection of a driver's license or for any other purpose where it is accomplished by the authority of the officers is an arrest. That's Robinson versus State. Perhaps it should be mentioned that as a general rule, a person is placed under arrest when he is deprived of his liberty by an officer who intends to arrest him. It's not always necessary for the officer to make, a formal declaration of arrest. So, if an officer see me and my partners, and we got on fitted caps, we got locks in here, man. We having long hair in here, man. Multiple melanated brothers in the same vehicle. And even though he has no reason to pull us over, and he still does, his intention is to make an arrest. So I'm deprived of my liberty by an officer who intends to arrest me. He ain't made a formal declaration of it, but I've been arrested. And any restraint, however slight, upon another's liberty to come and go as one pleases constitutes an arrest. I travel as I want to. So if this state police pulls me over, he's restraining my movement, however slight. No matter if he 10 minutes, hey man, take your license back, have a nice day. It doesn't matter. That's a slight restraint to come and go as I please, and that constitutes an arrest. So they're arresting us. No matter how nice they are on the side of the road. You remember, that's not your buddy. That's not your homie. It's so much BS going on. You got these state's attorneys making allegations against you. You got states. You got states attorneys making allegations against you. In Trenzi versus Pagliaro, an attorney for the plaintiff cannot admit evidence into the court. He's either an attorney or a witness. So, sir, it's only right for a matter of record that you be deposed, sworn in, and deposed. Other than that, it'll be in your best interest to shut your mouth, because you will be liable for any fraud you perpetrate upon the court, not me. There's no depositions. There's no admissions, no affidavits. The court has no facts to rely on for a summary determination. What do y'all have? There's no crime. You flat out trying to contract with me, bro. I really ain't got time for that. I ain't on that, man. You see what I'm saying? So you have to be, vigilant in studying your law. Would you not be a man, upright, independent, fearless, standing in the science and moving in the science of love, truth, peace, freedom, and justice, and make that your rock and hold it to your heart? And you need to know in your head that when a judge knows that he lacks jurisdiction or acts in the face of clearly valid statutes, especially depriving of him of jurisdiction, judicial immunity is lost. So that's why I tell you, hold that jurisdiction issue in your back pocket for a second, just in case they flat out tweak. Don't seem incompetent. Be subtle in your movement, but be firm in your posture. Don't go in there mugging people, looking crazy. Like, yeah, I'm here to tear y'all ass up. Yeah, I'm here to tear y'all ass up. I'm going to do it all so smooth. You get me to let my guards down, I'm just not. I'm going to make you think that my guards are down. Okay? So, we know that the law requires proof of jurisdiction to appear on the record of the administrative agency in all administrative proceedings. The law requires proof of jurisdiction. Well, did anybody address the issue of jurisdiction when I walked in there? No. Well, it says proof of jurisdiction on the record. Well, there's not even, I don't see a stenographer. So y'all can't even prove jurisdiction on what record? What record? How? How can you prove it? So, by me making a special restricted appearance, I'm there to strictly challenge the authority of this tribunal, but with respect to the proceeding. So, my private administrative process is a challenge. The prosecutor challenged me to a duel. And in law, where the onus probandi, Latin, for the burden of proof, rests on the man who brought the claim to court, he cannot shift it onto the man who challenges the reason why he brought you into court. So they tell us that we're innocent until proven guilty. Well, it seems like if you have been in the court, you're guilty until proven innocent, and then you stand to prove a double negative. We can't do it. That's like proving intent. You can't do it. You can't prove that. You can't prove that. So that lets us know that we ought to challenge the reason that someone brings us into court. I mean, unless you know you bogus, unless you know you wrong, and I mean this strictly in terms of common law, not statutory court. Now I'm gonna give you a gem. Courts that enforce statutes, they don't act judicially. Didn't I just say you the separation of powers? A statute is an act of the legislator. The judicial branch deals with law, real law. So, how is this a judicial proceeding? If you enforcing statutes, a court that enforces statutes doesn't act judicially because a statute is an act of the legislature. This could not be a judicial hearing. You're not serving the ends of justice. So we know if they railroad you and keep on going when you bring up the issue of jurisdiction, if you ever make it to that point, that once jurisdiction is challenged, the court can't proceed when it clearly appears that they lack jurisdiction. They have no authority to reach merits, which is decisions. But rather, they should dismiss the action. They're not going to dismiss it. I'm telling you that now. Once you challenge jurisdiction, you better know how to stand on it. That's why we keep it in our back pocket. We wish to remain anonymous. Now you say that. We wish to remain anonymous, so we want to come settle this. I'm not arguing none of the facts. I agree. Upon your proof of claim, you might as well get ready. You see what I'm saying? So the private administrative process is what's in place before you go to court. Okay? And the burden of proving jurisdiction rests upon the party asserting it. Huh? So this is not a court of record, then that means my due process is being violated. Where a court failed to observe the safeguards, it amounts to denial of due process of law. Court is deprived of jurisdiction. You failed to observe the safeguards. A court reporter. You deny me my due process of law if there's no record. You're automatically deprived of jurisdiction. We can't proceed. That's what I retorted. Oh, if there's no record, we cannot proceed. I know we can't proceed because you lack jurisdiction. You lack jurisdiction. So that's a strong issue. The law creates a presumption where the burden is on the party to prove material fact, peculiarly within his knowledge, and he fails without excuse to testify that his testimony, if introduced, would be adverse to his interests. The burden of proof. The problem of having to prove something is on the person who brings it into court. Sir, prosecutor. So we know we nationals. His burden of proving doesn't apply to you. It only applies to your monopoly piece. Your public fiction. What he talking about don't apply to you. Because you know you're outside, you exist outside of his society. But that doesn't mean you don't have the unlimited right according to Article 1, Section 10. Clause 1 of the United States, Constitution for the United States of America. We know that no state can pass a law impairing the obligations of contracts. So even though you do exist outside of his society, you have the unlimited right to contract with whoever the hell you want to, including a colorable de facto court of incompetent jurisdiction. Sir, sign this contract. Am I entering any contracts by passing a bar? No. I get you to say that on the record. Because All my lawmen out there, my law women, my muftis, my vanguards. We know that according to contract law, there's express and implied contracts. That's why you want it to be known for the record. Am I entering any contracts before I cross the bar? No. Okay, he said no. Then I can cross the bar because I set my safeguard in place. I set my safeguard in place before I went in. But all my students of contract, we know that it's implied if you walk past that bar that you enter into a contract. Yes, you are entering a contract when you pass that bar. You're implying to this colorable court that you agree to give them authority and jurisdiction over you to adjudicate this matter. That's why they always ask you, do you understand these charges? No, I don't understand nothing. Well, what don't you understand? I don't stand under your authority. Understand, I don't stand under your authority. Would you stand under another man's authority in front of your woman? That's pretty tough. Now, we have safeguards in place. We're protecting ourselves from this adversarial proceeding, this assault that you are getting ready to take on me, on my person, on my mind, on my emotions, on my adrenal glands, on my heart, on my mental state. He's finna get ready and wage war on you. Maybe because he's trading with his enemy. Trading with the Enemy Act. Go look it up. You've been declared a enemy of the United States. Why? Because you're outside of it. And what's outside of the United States? The 50 states of the Union. They are outside of the federal corporation, the 10 square mile of the District of Columbia and its insular possessions. That's the United States. 28 U.S.C. 3002-15A states that the United States means a federal corporation. You are enemy of this federal corporation, according to the Trading with the Enemy Act. And once you study and go into authorities on law, like 70 American Jurisprudence, the second section, 57, Title 7, Civil Liability, an officer may be held liable in damages to any person injured in consequences of breach of any of the duties connected with his office. The liability for nonfeasance, misfeasance, or for malfeasance in office in his individual, not his official capacity. That man knew he was dealing with another man. Don't you see a man behind you, Buddha? 15 bucks. Aryan interest, motherfucker. That's a man, Buddha. Don't you see a man behind you, Buddha? Don't you see a man standing in front of you, coward? That's what that coward seen. He seen a man standing in front of him. And I have the remedy of holding him liable in damages in his individual capacity. So that man has to come back and see me. Oh yeah, we finna shoot the one. I'm finna tap that ass. With this. The pen is mightier than a sword. I'm finna get on his ass with this. And with this. And with this. I can defeat him physically. I know I can. You don't know what I've been through. But I'm a distinguished nobleman. I'm a distinguished gentleman. I'm a Moorish American Illinoisan. A man of honor, integrity, morals, values, principles. And I'm standing on the 5 highest principles known to man: love, truth, peace, freedom, and justice. And I hold that true to my heart. If you look on my flag, the flag of my ancestors, my Moorish flag, my Moroccan flag, there's a green pentagram. And it's pointing upwards. It's upward. It's not inverted. And we represent the highest 5 principles. And while we in this material world, we exercise our 5. What's that 5, bro? What that 5 mean? Our 5 senses. Smell, sight, taste, hearing, and sensation, touch. We exercise in that 5. I'm feeling these sensations when I walk up in this place. You see what I'm saying? So we know that once the government, starts operating in commercial affairs, you abandon sovereign capacity. You're reduced to the mere pains of a corporation. So, the party in interest may become liable for fraud by mere silent acquiescence and partaking of benefits of fraud. So, even though Mr. Prosecutor Man, the one who he really trying to get off on you, his partner finna help him. So the judge knew, hey man, let me get out of here, man. Because if he know this, he finna get on somebody's ass. You just became a party of interest now. You're going to be liable for fraud because you're silent acquiescence and the partaking of benefits of this. It was going to benefit you to get a conviction, my boy. That kickback was going to be nice, wasn't it? You just created joinder with your boy. Now, he went from being able to get his ass whooped on his own to y'all conspiring against my rights. Now, if I were to come out in the public and use my monopoly piece to bring suit against them, I will be bringing action under the criminal code of the United States, the criminal section of the United States Code, 18 U.S.C. 241 and 242, deprivation of rights under color of law. It wasn't a court of record. That's color of law. Let me go back to color once again, and I keep ending up on this word. I keep ending up on the word color. I keep ending up on this word, right? Because I need you to understand that according to Black's Law Dictionary, page 331, the 4th edition, it says color is an appearance, a semblance, or simulacrum as distinguished from that which is real. A prima facie means, at first glance, on his face, a prima facie or apparent right, hence a deceptive appearance. A plausible, assumed exterior, concealing a lack of reality, a disguise or pretext. It says an assumed exterior. That's the word color. Let's see what color of law is, a couple sections down. The appearance or semblance without the substance of legal right. Color of authority. The semblance or presumption of authority sustaining the acts of a public officer which is derived from his apparent title to the office or from a writ or other process in his hands apparently valid and regular. Color of authority. So, you're conducting acts that's associated with your office, but you're not doing it on record. and you're joining someone else and trying to scam me. That's a color of authority, my boy. That's color of authority. So, you see how 18 USC 241 and 242 applies? Color. Deprivation of rights under color of law. Did not they deprive me of my rights by putting me in handcuffs, taking me down to the county jail, making me stay the night for driving with no license, and I have the right to travel on the land without a license? Have I not been deprived of my rights? Then they invited me to come into court with a no record to contract with them? Is that not color of law? Is that not deprivation of rights under color of law? And this is for information, educational, and entertainment purposes only. If you dare use this, you better train and use it at your own risk. If you don't know what you're doing, don't go in there playing. You're going to make it bad for yourself. And for the people who are intimidated, just realize you can start with the basics. Learning the words. Get you a Black's Law Dictionary. Learn the words. Learn what they're saying, because they're speaking legalese. I don't believe it's in here, but let's see. Nope, it's not in here. So, I mean, if it's not in Black's Law Dictionary, let's go find it right here. Boom. Bam. All right. Legalese. That's the language of the courtroom. My men and women. Legalese. The specialized or technical language of the legal profession, especially when considered to be complex or abstruse. A style of writing or speaking heavily emphasizes that the abstruse technical vocabulary of the law, to the point where a speech or document may be incomprehensible to non-specialists. The technical talk of the legal profession, the argot of lawyers. So let me go show you what they mean by heavily emphasizing the abstruse technical vocabulary of the law to the point to where speech or the document is incomprehensible. And we can find that, an example of that, in the Uniform Commercial Code. And let's go to accommodation. In the Uniform Commercial Code, let's just see section 3-419, instrument signed for accommodation. And before I start reading this, let me jump back and tell you while I'm reading this, if you forgot that quick. I'm reading this to show you an example of a style of writing or speaking heavily emphasizing the abstruse technical vocabulary of the law, to the point where a speech or document may be incomprehensible to non-specialists of the law. UCC 3-419. Section B. An accommodation party may sign the instrument as maker, drawer, acceptor, or endorser, and subject to subsection D, is obliged to pay the instrument in the capacity in which the accommodation party signs. The obligation of the accommodation party may be enforced notwithstanding any statute of frauds, and whether or not the accommodation party receives consideration for the accommodation. Section C. A person signing an instrument is presumed to be an accommodation party, and there is notice that the instrument is signed for accommodation if the signature is anomalous endorsement or is accompanied by words indicating that the signer is acting as a surety or guarantor with respect to the obligation of another party to the instrument, except as provided in section 3-605. The obligation of an accommodation party to pay the instrument is not affected by the fact that the person enforcing the obligation had notice when the instrument was taken by that person that the accommodation party signed the instrument for accommodation. Now, If that's not confusing, I don't know what is. If that's not a style of writing or speaking heavily emphasizing the abstruse technical vocabulary of the law to the point to where the speech of the document may be incomprehensible to the non-specialists of the law, then I don't know what is. If that's not the specialized or technical language of the legal profession, especially when considered to be complex or abstruse, I don't know what that is. So maybe we need to figure out what abstruse means. Let's see what that means. Difficult to understand. Concealed or hidden out of the way. Remote from apprehension, difficult to comprehend or understood. Did it not? Why do you think they call it the United States Code or the statute codes annotated? They're coding what they're trying to say in technically difficult words that are abstruse. Is that not a labyrinth or a maze? Are you not going down the yellow brick road when you crack open a statute book? Because the law is concise, scientific. The law says what it means. You have the right to keep and bear arms. How could that be construed to mean anything else? How could that be construed to be anything else? So we know that they're speaking a different language, legalese. So don't go in there playing games. You invoke the judiciary, the Article 3 side of the court, by remaining in your proper person and operating as a national. Because we don't, well, according to statute, Blase Skippy 1,001,110,1202, it says that you could do that, but technically I don't have to do. You don't go in there arguing statutes. It's you just jumped into the rabbit hole. Treated yourself. Don't go in there arguing statutes. But you keeping it simple as a national. When a citizen challenges the act of a federal or state official as being illegal, that official cannot just simply avoid liability based on the fact that he's a public official. Oh, I'm a public official, man. Bro, ain't nobody trying to hear what you talking about, bro. I do this. I'm a judge. I finesse shit all day, boy. You want to come here and say something, bro? I'm a public official, bro. I don't get on, my boy. Bailiff. Check him. He gonna send his minute on you. Point blank, period. And is it not equality of the law? Are we not reserved the right of equality to law? That means not only do equally I benefit from the law, but equally each man must be punished. Including the who? A black robe, an officer, I don't give a damn who you is. So, in Williamson versus the United States Department of Agriculture, when lawsuits are brought against a federal official, they must be brought against them in their individual capacity, not their official capacity. So, we don't want to get too far off subject, but that's just to help you understand. If you don't get your remedy in the moment, know that your remedy still exists. Know that your remedy still applies. But we put so much focus and attention on our private administrative process and putting teeth in and make sure you dotting your I's and crossing your T's that we don't have to make it to that point. We get the cowards to bow down before we have to go that far. For informational purposes. So, to my good men and my good women, put your safeguards in place before you walk in these places. Precede yourself with your special restricted appearance. Precede yourself with your private administrative process. You know? And if you have any inquiries on how to do this, my email is in the bio. The link, the description. The information is free. The information is free. You just donating for my time. You donating for my time. This is non-profit. We just take, So learn and be grounded and understand that what they used to sing back in church, God has not given us the spirit of fear, but the Lord has given us power. All right? Power. We moving in the science of the 5 house principles known to man. Love, true peace, freedom, and justice. And once again, I am the Sagent, Eternal Lamont L, an undaunted national. If any of this information was informational, educational, or entertaining, then please subscribe. Drop a thumbs up when you come in and subscribe to the channel. Peace and love.